Hello and welcome to the Minimum Competence episode for Wednesday, July 17th, 2024. I'm your host for today, Andrew Leahy, a tax and technology attorney from New Jersey. On today's episode, we have President Biden's Supreme Court reform proposals, conflicts involving former Judge Kindred, a ruling on gun permits in Minnesota, Tesla's legal team change, and a probe into ex-Judge Jones. Let's remember, taxes are what we use to purchase a civilized society, and read today's legal news. On this day in legal history, July 17th, 1862, President Abraham Lincoln signed the Second Confiscation Act into law, marking a significant legal development during the Civil War. This act allowed for the seizure of property owned by individuals engaged in rebellion against the Union. Unlike previous measures, it did not require due process or provide an opportunity for the accused to defend themselves. The act targeted Confederate supporters, intending to weaken the rebellion by stripping resources from those aiding the Confederate cause. The legislation also declared that enslaved people who escaped from rebel owners or were captured by Union forces would be considered free. This move was a precursor to the Emancipation Proclamation and signaled a shift in Union policy towards a more aggressive stance against slavery. The Second Confiscation Act was controversial as it raised significant legal and constitutional questions regarding property rights and due process. Critics argued it overstepped executive powers and violated the Fifth Amendment. Despite these concerns, the act was a critical step in undermining the Confederate war effort and advancing the Union's moral and strategic objectives. It reflected the growing commitment of the Lincoln administration to not only preserve the Union, but also to end slavery once and for all. The Second Confiscation Act thus played a pivotal role in the broader legal and political landscape of the Civil War. President Joe Biden is preparing to introduce proposals for significant Supreme Court reforms, including imposing term limits on justices who currently serve for life. This marks a notable shift for Biden, who has previously resisted such reforms despite pressure from within his own party. The proposals also include an enforceable ethics code for justices and a constitutional amendment to overturn a recent Supreme Court decision granting broad immunity to presidents for official actions. However, these changes are expected to face considerable challenges in becoming law, especially with Congress unlikely to address major legislation before the upcoming election. Biden's proposals come amidst a tight race against former President Donald Trump, who leads in public opinion polls. Congressional Republicans are expected to oppose the reforms, viewing the current conservative Supreme Court as a significant political achievement. The White House has yet to consult with key lawmakers about the plans, and Press Secretary Karine Jean-Pierre has declined to comment. Biden hinted at these proposals in a recent call with the Congressional Progressive Caucus, aiming to garner support after a poor performance in a presidential debate. The Democratic push for Supreme Court reform has grown following several controversial rulings, including the overturning of Roe v. Wade and the rejection of Biden's student loan cancellation plan. Justice Clarence Thomas has also faced scrutiny for not disclosing expensive gifts from conservative donors like Harlan Crow. The court's decision granting presidential immunity for official acts has further complicated efforts to prosecute Trump, and Biden criticized this decision, arguing it contradicts the founder's intentions. In response, Trump accused Democrats of undermining the Supreme Court and interfering in the presidential election. Federal prosecutors in Alaska have identified 23 criminal cases with potential conflicts of interest involving former U.S. District Judge Joshua Kindred, who resigned following sexual misconduct allegations. The Ninth Circuit Judicial Council reprimanded Kindred for creating a hostile work environment and engaging in an inappropriate relationship with a law clerk. Although the clerk did not work on cases before Kindred, potential conflicts existed in other cases. Brian Wilson, not the Beach Boy, but instead head of the U.S. Attorney's Office Criminal Division, detailed the conflicts in an email to Alaska's federal public defender. These conflicts included interactions between Kindred and several attorneys, such as a senior prosecutor who sent him nude photos, and another attorney who exchanged flirtatious texts. These undisclosed conflicts could lead defense lawyers to challenge convictions or sentences from cases Kindred oversaw. The U.S. Attorney's Office had taken steps to mitigate conflicts since late 2022 by notifying the district's chief judge and reassigning cases from Kindred. However, federal public defender Jamie McGrady criticized the office for not disclosing the conflict sooner and noted that the recusal of Kindred did not eliminate prejudice against defendants. Her office plans to investigate all cases involving attorneys who interacted with Kindred to ensure justice. A federal appeals court ruled that Minnesota's law requiring individuals to be at least 21 to obtain a permit to carry a handgun in public for self-defense is unconstitutional. The 8th U.S. Circuit Court of Appeals found the law violated the Second Amendment rights of 18 to 20-year-olds. U.S. Circuit Judge Dwayne Benton, writing for the panel, emphasized that the Second Amendment does not specify an age limit. The court upheld a previous ruling in favor of the Second Amendment Foundation, the Firearms Policy Coalition, and the Minnesota Gun Owners Caucus, which had challenged the law. The decision referenced the 2022 Supreme Court ruling in New York State Rifle and Pistol Association v. Bruin, which set a new standard for evaluating firearm regulations, stating they must align with the nation's historical tradition of firearm regulation. Judge Benton noted that Minnesota failed to show that 18 to 20-year-olds posed specific risks that justified the age restriction. Despite this, the Supreme Court had recently upheld a federal ban on gun possession for individuals under domestic violence restraining orders, indicating that certain modern firearm restrictions could be valid without historical precedent. Minnesota Attorney General Keith Ellison expressed disappointment with the ruling, arguing it complicates efforts to reduce shootings and enhance public safety. The decision is part of a broader trend of gun rights groups challenging age-based firearm restrictions in various states. Tesla has replaced its longtime law firm, Cravath, Swaine & Moore, with Wilmer, Cutler, Pickering, and Hale in a California class action antitrust case. This change, noted in court records, comes as Tesla faces allegations of monopolizing the market for vehicle parts and services, which has purportedly led to consumers paying higher prices. The reason for the switch was not disclosed, and neither Tesla nor the involved law firms commented. The class action case saw a significant development in June when a judge refused to dismiss the claims against Tesla. Shortly thereafter, Wilmer attorneys made their debut appearance for Tesla, continuing to deny the plaintiff's allegations. Tesla and Musk have a history of legal representation by both Cravath and Wilmer in various high-profile cases. Musk is also represented by Cravath in a Delaware lawsuit challenging his $56 billion pay package, a case that faced a setback in January when a judge invalidated the compensation. Despite a shareholder vote in favor of Musk's pay in June, the Delaware litigation continues, with Quinn Emanuel recently joining the defense team. Wilmer is defending Tesla in another antitrust lawsuit in New Orleans, where it seeks to overturn a ban on direct-to-consumer car sales. The questioning of former bankruptcy judge David R. Jones, who resigned after revealing a secret relationship with a partner at Texas law firm Jackson Walker, has been postponed. The U.S. Trustee's Office is investigating to recover over $13 million in fees Jones approved for Jackson Walker without disclosing the relationship. Chief Judge Eduardo V. Rodriguez of the Houston Bankruptcy Court is deliberating on whether the questions about Jones' recusal decisions and his relationship with the attorney violate judiciary policy. Jones, who resigned last year, had a relationship with Elizabeth Freeman, who left Jackson Walker in late 2022. The deposition, originally set for July 18th, is on hold until Judge Rodriguez determines the appropriateness of the questions. Jones' attorney, Benjamin I. Feinstone, argues that questions about Jones' conduct are a distraction and that the focus should be on what Jackson Walker knew about the relationship. Jackson Walker's attorney, Jason Lee Boland, asserts that understanding the timeline of Jones and Freeman's relationship is crucial for defending against the U.S. trustee's efforts to reclaim the fees. Judge Rodriguez emphasized the complexity of addressing questions about judges' recusal decisions, stating that such decisions should not be publicly questioned. U.S. trustee attorney Laura Steele argued that Jones' public statements about his recusals allow for relevant inquiries. The case, known as Professional Fee Matters Concerning the Jackson Walker Law Firm, continues as the court navigates the boundaries of questioning a judge's conduct and recusal decisions. And with that, I thank you so much for listening to Minimum Competence, your daily news podcast for lawyers. If you're looking for more than minimum competence, links to further reading on all the topics touched on today are in the show notes. And reviews go a long way towards helping new listeners to find our show. If you have a moment, leave a rating or review on your podcast player. We'd sure appreciate it. And if you know someone that might be interested in the story we cover, consider sending them the episode. But remember, nothing here should be construed as legal advice because it is certainly not that. Minimum Competence is available at minimumcomp.com and wherever you get your finely crafted podcasts. If you haven't checked out the website in a while, give it a look. There are complete transcripts and resources for each episode and its corresponding segments, as well as an opportunity to receive new episodes in email, newsletter, form. We'll see you back here tomorrow, and until then, remember, the right to swing one's fist ends where the other person's nose begins.